Imagine completely disrupting 20 years of campaign finance rules overnight. That's exactly what could happen if one Supreme Court case goes a certain way. And it might completely change how political parties raise and spend money. Let's break it down. I'm Eric Wilson, and we're unpacking NRSC versus FEC, why the National Republican Senatorial Committee took the Federal Elections Commission to court, what's at stake, and how that decision could reshape campaign strategy for both parties. Every campaign finance discussion circles around three questions. One, who can give you money? Two, what can you spend that money on? And three, what do you have to disclose? So keep those in mind because that's what drives everything else that follows. So we need to flash back to the early 2000s. Congress passed the McCain-Feingold Act, and it answered those three questions in these ways. First, only individuals could donate to candidates and party committees, and that was up to a capped amount. Second, the candidates could spend that money on their own primary or general election, and there were limits on how much groups like party committees could spend as well. And third, they had to disclose those donors above the set threshold and how they spent every dollar. Then came a string of court challenges, most famously Citizens United in 2010, and that ruling opened the door for super PACs, outside groups that can take unlimited money, even from corporations, as long as they disclose it. So originally, super PACs had to stay totally separate from candidate committees. There was no coordination, and there were a lot of weird workarounds like cryptic tweets, public strategy memos to nobody, and really awkward B-roll footage for super PACs to cut ads with. But over time, that no coordination wall has cracked. Meanwhile, the party committees have been forced to build these expensive firewalls that lead to duplicate staff and legal bills to keep their coordinated and independent spending separated. So the NRSC says those coordination limits waste money and weaken parties, while outside super PACs are more free than ever to do what they want. They're asking the Supreme Court to scrap the rule that separates coordinated and independent expenditures for those party committees. And so if the Supreme Court sides with the NRSC, here's what we would expect to happen. There would be no more internal firewalls. Parties could plan directly with their candidates, so no duplicate teams, no extra legal bills. There would be cheaper ad rates. Party committees would stretch their dollars further by getting access to those candidate rates for TV advertising, mail, things like that, that don't apply to super PACs. More money would be spent on direct voter contact. So less money going to overhead, all those duplicate expenses, that's going to go downrange to campaigns and contacting voters. And lastly, we're going to see clearer roles. Parties would handle the coordination with candidates, and super PACs would stay fully independent and do the advertising and other activities that they're able to do.